Hi, it's Mike DelSignore, Massachusetts criminal defense lawyer. Today's video, I want to talk about what happens at a clerk magistrate hearing. So clerk magistrate hearing, you get a notice from the clerk telling you that you have a case in court. Usually the caption of the title will be the police department versus you instead of Commonwealth, as if it was an arraignment, it would be Commonwealth versus you. So this is a private matter right now between you and the police department. You likely got a ticket many months before, or maybe even a month before, and you went to the clerk's office, you turned it in, they set it up for a clerk hearing. Many courts now will schedule these without even submitting the citations. It's always good practice still to submit it. Some of the courts are on the old practice where you had to drop it off. But a clerk magistrate hearing is a meeting between you, the clerk, the police prosecutor. What happens is the prosecutor reads the report and argues to the clerk that there's probable cause. And generally there is probable cause. Clerk magistrate hearings are commonly for OUI charges, where there was an accident, you went to the hospital, meaning you weren't arrested, negligent operation, leaving the scene of property damage, shoplifting, sometimes assault and battery. Those are the types of cases you'll often see at clerk magistrate hearing. So let's take the motor vehicle charges, like leaving the scene, negligent operation. A clerk hearing is a great opportunity to try to show the clerk that everything's taken care of, that the property damage has been covered. If it's a negligent operation, you generally don't want to argue the probable cause. Generally, they're going to have probable cause to charge you. But if you go there, show them that you're taking it seriously, you've hired a lawyer. Sometimes all of my clients do programs proactively, like if it's alcohol related, I have a bunch of different processes. I have the person do AA, alcohol treatment, and it worked recently for a clerk hearing when my client did not have OUI charges issued because of all the proactive steps done before the hearing. For negligent operation, sometimes you can do the Brains at Risk program ahead of time, things like that show the clerk that you're really taking this matter seriously. And we present your background, the fact that you're employed, things that are going on in your life, in order to get the clerk to basically keep the case open for a period of time, with the idea that if you do any programs they assign you to, if you stay out of any further difficulty, the case will eventually get dismissed. And the reason why that's such a great outcome is because it doesn't appear on your criminal record. Sometimes clerks will say they got to issue the complaint. If they do, you're still presumed innocent. You still can potentially work out a similar resolution with the prosecutor. So you still may avoid a criminal conviction, especially for negligent operation, leaving the scene. Those are commonly cases where you can work those out without a conviction, without further license loss. So I've been helping people with criminal charges in the district court for over 20 years. My name is Mike DelSignore. Feel free to call, text, reach out anytime. I'm glad to help you. 781-686-5924.